Before we get started, please go over to Amazon.com and grab a copy of my book, Education and Justice. If you have an African-American son in public school, you need this book because I teach you the many ways that public schools mistreat African-American boys and what you can do to help your son. So go over there and get your copy immediately. All right, before I get into this video, really, which is about Trump's tariff case that was heard in front of SCOTUS yesterday, before I talk about that, let me take this opportunity to thank all the black men who turned out big, especially in support of Proposition 50 in California. That was really huge. And from what I understand, from what I read, black men turned out in bigger numbers than black women this time to support Proposition 50, which will allow California to redraw its voting map, which potentially will give the Democrats 5 additional seats to try to offset the seats that Trump is trying to get here in Texas, which is basically a way to rig the 2026 midterm. Okay? But anyway, thank you, brothers. Thank you, thank you, thank you, thank you. I know that I have said a lot since the election last year, in fact, a year ago. I've said a lot about the fact that an increasing number of black men voted for Trump. Most black men still voted for Kamala last time. So let's not lose sight of that. But an increasing number, and enough black men voted for Trump to help him win this election. But a year in, apparently, hopefully, brothers are seeing that this man is not for us. Project 2025 is definitely not for us. MAGA is not for us. And so what they did in many instances was they took advantage of the frustration that many younger black men have, and rightfully so, with the Democratic Party and what it needs to do more of, as well as the perception of how bad the economy was last year. Now, I would argue, and I did argue, that the Biden-Harris administration did a lot for the African-American community. But not everybody knew about it. Not all the brothers knew about it. They did a poor job of really bragging upon themselves. So a lot of black men just simply did not know what the tangibles that they provided. All right, so an increasing number went from 8% in 2016 to about 24, 25% in 2024. It increased in 2020 and even more so in 2024. Maybe that fever is breaking. Maybe that fever is breaking. Hopefully, fewer and fewer black men are listening, especially to those who say don't vote, or those who say the Democrats and the Republicans are the same. All right, maybe that fever is breaking. I am hoping, because all of that is garbage. There never need to be a time where we don't vote. And when you look at who's anti-black and who is pro-black, or at least who have helped black folks over the last 80, 90, 100 years, the facts are just really, 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 really simple. So simple, so ascertainable that all you got to do is Google. Just do a simple Google search, and that will shut down a lot of that disinformation that has been targeted to our community. But I just want to say thank you. Thank you, brothers. We really needed Prop 50 passed. We really, really needed it. And you also showed up big in the Commonwealth of Virginia, as well as New Jersey, and you showed up big in New York. So you made your voice and power felt. That is what I love, really. So again, thank you. Now, Trump tariff case is a pretty big case. It is probably as big as the absolute immunity case. I think back in 2023, I think, or could have been 24. It's a real big case, this case on tariffs. And Trump knows it. He said as much. And so the case went in front of SCOTUS yesterday. It was brought by several groups of plaintiffs, one of which is called the Learning Resources, Inc. They sued because their prices began to increase on the products they needed for their business. So they brought a lawsuit, and then another group of folks brought a lawsuit, and they were consolidated into the case that went in front of SCOTUS yesterday for oral argument. So I got the oral argument. We're going to listen to the first few minutes of it, and I'm going to explain. That's all I need, just the first few minutes to explain to you what this is all about and why it is so important. So what it's about in 3 words: tariffs, taxes, takeover. So basically, are Trump's tariffs really taxes that are enabling him to take over more executive power? That's what this case is about. Are Trump's tariffs really taxes that the American people are paying, which are also allowing Trump to take over more executive power? Those 3 words, remember those words, they're going to keep coming up. Tariffs, taxes, and taking or takeover. All right, so let's go to another screen. We're going to start listening to the oral argument, and I'm going to have to come in. I don't want to interrupt it, but you will not understand most of what's being said. You won't get the gist and the essence of what's being said unless I explain it. All right, so hang in there, but you're going to understand this. I'm going to make it so plain. I'm going to take these convoluted, complicated legal doctrines and break them down such that a 10-year-old could understand. All right, so stay right there. Let's do this.
87, Learning Resources versus Trump, and the consolidated case. General Sauer.
Mr. Chief Justice, and may it please the Court. On April 2nd, President Trump determined that our exploding trade deficits have brought us to the brink of an economic and national security catastrophe. He further pronounced that the traffic of fentanyl and other opioids into our country has created a public health crisis, taking hundreds of thousands of American lives. President Trump has declared that these emergencies are country-killing and not sustainable, that they threaten the bedrock of our national and economic security, and that fixing them will make America a strong, financially viable, and respected country again. Due to IEEPA tariffs, President Trump is negotiating.
All right, let's stop there. So he said, the president said, and issued several executive orders saying that there were 2 emergencies going on, at least 2, the 2 that he used to impose tariffs. 1, trade deficits. 2, fentanyl coming across the border. So he saw those in his executive order. He said this is a national security crisis, emergency, and the fact that you got a lot of folks dying from fentanyl, from products that are coming from overseas, that is an emergency as well. And he needed to designate those situations as emergencies in order for him to invoke the law to impose the tariffs. All right. So you also heard the word IEEPA, and that's just an acronym for a statute that Trump used to say it gave him authority to impose the tariffs. All right. IEEPA is spelled IEEPA, maybe just 2 E's, but I believe it's 3 E's, IEEPA. And it's just a long name, again, for a federal statute that the president says gives him the authority to impose the tariffs. All right, let's go back to the recording.
Negotiated agreements worth trillions of dollars with major trading partners, including most recently China. Unwinding those agreements, he warns, would expose us to ruthless trade retaliation by far more aggressive countries and drive America from strength to failure with ruinous economic and national security consequences. In Dames and Moore against Regan, this court held that IEPA's sweeping and unqualified language grants the president's actions the strongest presumption of validity and the widest latitude of judicial interpretation. Yet plaintiffs argue that tariffs, IEPA's least blunt.
Now, Dames and Moore versus Regan is an old case, goes back to the 70s, that they're using to say the president's authority is pretty broad under that case to impose these tariffs. All right. So they're hatching their wagon so far to two things. That is IEPA, Dames and Moore, and they're going to attach their wagon to something else here in just a moment. But those are the authorities, because in the law, if we're going to do something and then go in front of courts, you got to show that there's authority, there's law, you have the legal basis to do whatever it is you did or whatever motion you're making or so on. So those are the authorities that they're using so far. But the third one, you'll hear in just a moment.
Blunt and most nimble tool are virtually the only tool that Congress did not grant the president to deal with foreign emergencies. That is wrong. The phrase regulated importation plainly embraces tariffs, which are among the most traditional and direct methods of regulating importation. And plaintiffs concede that IEPA authorizes quotas and other tariff equivalents. The major questions doctrine does not apply here. IEPA confers major powers to address major problems on the.
All right. Now, major questions doctrine is a legal doctrine that requires the president to get congressional approval if it involves a major question, if it involves a major issue. And certainly imposing tariffs to the tune of trillions of dollars, that certainly is a major question that typically would require congressional approval. But they're arguing, Trump and his lawyer are arguing that the major question doctrine doesn't apply here, and he's going to say why. And there is also another doctrine that you're going to hear him say in just a moment, that it doesn't apply. Let me just go on and explain it to you so that I don't have to come in there. The non-delegation doctrine, that simply means that they're arguing that Congress delegated certain authority to Trump, and that gave him the authority as well to do the tariffs, or the fact that they didn't delegate him any authority to do so. That doesn't matter because he has certain Article 2 authority. Article 2 is the section of the United States Supreme Court that sort of outlines what the duties, what the power, the authorities, the responsibilities of the executive branch, the president. And then Article 1 is that part of the Constitution that lays out the duties, the authority, and so forth of Congress. And then Article 3 lays out, creates, and all of that of federal courts, okay, Supreme Court and the lower courts. All right, so they're arguing that they don't need congressional approval, and the non-delegation statute doesn't apply here either. That legal doctrine doesn't apply. It's not a statute, but that legal doctrine.
On the president, who is perhaps the most major actor in the realm of foreign affairs. And the non-delegation doctrine casts no doubt on IEPA because Congress may assign the president broad authority regarding the conduct of foreign affairs where he enjoys his own inherent Article 2 powers. I welcome the court's questions.
Would you spend a few minutes on why exactly the major question doctrine doesn't apply to the president in this case?
Yes, Justice Thomas.
So Justice Thomas, that's who spoke here, he is likely in support of what Trump's doing. So he's trying to help out Trump's lawyer by asking him a really softball question. I mean, that's just a toss across the plate. I mean, he should be able to knock that out of the park. All right. So that's what that was. Him and Sam Alito, they seem to be in support of Trump's tariffs. You could say just about everything Trump's doing. I think they were they sided with everyone else in one instance. I can't remember what that was about. I think whether or not Trump had to respect the due process rights of people, despite him invoking the Alien Enemies Act. I think that's what they did vote against Trump on. I think that was a unanimous decision. All right. Let's go back.
And I maybe make 2 or 3 points on that front. First of all, though the major questions doctrine may apply to the president in other contexts, specifically in the foreign affairs context where he has his own inherent Article II authority, it's a particularly poor fit to apply the major questions doctrine. And that's for at least 2 reasons. First of all, just as a matter of kind of common sense interpretation, one would expect Congress to confer major powers on the president to address major, sort of international crises, so to speak, in foreign arising emergencies, that's just sort of a natural common sense thing you expect Congress to do. And in fact, Justice Jackson, in his Youngstown opinion, addressed this very situation in pages 652 and 653, when he says, this is the system this is the procedure within our constitutional system that we have developed to strike the balance. What Dames and Moore described as the never-ending tension between the need for the executive to have robust powers to address emergencies and to subject it to checks and balances. What our constitutional system has devised to address that particular problem, that never-ending tension, is the system where Congress confers broad and necessary powers in advance and subjects them to ongoing political oversight, which is exactly what you see in IEPA. So that's one reason. One reason, just as a matter of common sense interpretation, you would expect Congress to grant major powers to the president, who has his own broad range of major authority, inherent Article II authority in this context. And that is buttressed by the second point.
General, there, and I know that you have a second question, and I want to let you get to that. But just on that first reason, it seemed to depend a lot on the president's inherent Article II power.
This is Justice Kagan. She is one of the liberals on the court. All right. And you just heard Sauer just basically argue that under Article II of the Constitution, and just given the fact that a lot of this involved foreign issues, and that is something that the president typically has a lot of authority under, pursuant to Article II. So that's basically his argument as to why the major questions doctrine does not apply here to the president. In other words, he doesn't need congressional approval. All right, so Justice Kagan is about to ask a very important question.
Powers. And I'm wondering which powers you're speaking of there, because tariffs, one would naturally think, are the power to impose taxes, the power to regulate foreign commerce. These are not things that are thought of as Article II powers. They are quintessential Article I powers. So what kind of Article II powers are you relying on when you gave the answer about major questions to Justice Thomas?
I would refer to what the court said, for example, on Egan, Department of Navy against Egan. That's a generally accepted view that the president has broad authority in the foreign affairs realm. Now, there's debates about exactly how far it goes and how to draw the boundary between the president and Congress, but Egan, Garamendi, other cases, Curtis Wright, the court has recognized the president has broad inherent authority to address foreign situations, foreign affairs, foreign policy, including foreign arising emergencies. Now, we don't contend that he has, at least in peacetime, inherent tariffing authority. What we have here is 2 layers. There's the layer, the bedrock of the president's, inherent Article II powers, and layered on top of that is a sweeping delegation of authority from Congress. When you put those 2 things together, Congress is saying you have inherent powers to address international emergencies, and we're conferring on you the tools, including Article I tools, like, for example, the power to regulate foreign commerce. And I want to make a very important distinction here. We don't contend that what's being exercised here is the power to tax. It's the power to regulate foreign commerce. These are regulatory tariffs. They are not revenue.
Now, I told you in the beginning, this is about tariffs, taxes, and taking over. So we heard his general layout regarding tariffs. Now we're getting into the tax part, whether the tariffs are really just taxes. All right. And if they are taxes, then the president doesn't have the authority to impose taxes. That's the tension. That's the rub. The rub is whether or not the president has the authority to impose taxes, even by way of tariffs, or in this case, especially by tariffs. All right. So now that's getting ready to come out.
revenue-raising tariffs. The fact that they raise revenue is only incidental. The tariffs would be most effective, so to speak, if no person ever paid them, if they achieve their goals. If they
Counsel, you've already mentioned Dames and Moore three times, which surprises me a little because the court in Dames and Moore went out of its way to say that it was issuing a very narrow decision that pretty much expected to apply only in this case. Just a few quotes. It said, decisions in this area have been rare, episodic, and afford little precedential value for subsequent cases. Again, we lay down no general guidelines covering other situations not involved here and confine the opinion only to the very questions necessary to decision of this case. And it ended the opinion. It said, finally, we re-emphasize the narrowness of our decision. Now, this at issue in Dames and Moore was a different provision of IEPA, not at issue here, and certainly did not concern tariffs. So I don't quite understand how you can get as much out of Dames and Moore as you're trying to get.
All right, so the Chief Justice said essentially here, you are biting off more than we intended for anyone to bite off using Dames and Moore. All right, we wrote a very narrow opinion. In other words, we cut a very small piece of the pizza for people to take. All right, and you have taken half the pizza or even more to try to make your argument and defend what Trump has done. And the Chief Justice, who, by the way, clerked for William Rehnquist, who actually wrote this Dames and Moore case versus Reagan. So he ought to be very familiar with it, and he is. So he's taken upon himself to say, you are overreaching with this case. All right, let's listen to his response.
Maybe I could put it this way. We don't dispute that Dames and Moore is, as you stated, narrow opinion. However, it addressed certain principles that we think are equally applicable here. For example, the interpretive principle. Dames and Moore held, and again, it was the power to nullify and void, not the power to regulate, but it's in the very same sentence, in the very same statute, and the court quoted the First Circuit opinion and said, look, this is sweeping and unqualified language, which it didn't disagree with. And then it said, this particular provision where Congress has given these broad verbs, I mean, regulate is a capacious verb, admittedly, so are nullify, so are void, so are frankly all the other verbs there in the language in IEPA. The way the court thought about it is we are looking at this through the lens of Justice Jackson's opinion in Youngstown, and the court held specifically that these verbs place the president in Youngstown Zone 1. The court held that he's subject to the widest latitude of judicial interpretation, that he receives the strongest presumption of validity.
I just don't understand this argument. It's not.
It's Justice Sotomayor, and she's not for it, obviously. She and Justice Kagan, they're not for it, and Justice Jackson. Going to hear from her as well. And I hope you notice that I don't think we're going to get there, but they're going to talk a whole lot about verbs, okay, about various verbs that they're going to rely on. And so let's just keep listening.
Not an article. It's a congressional power, not a presidential power to tax. And you want to say tariffs are not taxes, but that's exactly what they are. They're generating money from American citizens, revenue. And you say it's incidental to the regulatory purpose. But I don't see how a quota is equivalent to revenue raising. A quota sets a limit to what you can import in, but it doesn't generate revenue. I don't understand this argument, that it's equivalent, or that foreign powers or even an emergency can do away with the major questions doctrine. Didn't we in the Biden case recently say an emergency can't make clear what's ambiguous?
As to that point, I believe the court has never applied the major questions doctrine in the foreign policy context.
So when Biden did the student loan forgiveness, he was sued by many states' attorney generals and state attorneys general. And one of the issues was whether or not he needed congressional approval pursuant to the major questions doctrine. And the court said yes. But in this instance, the Trump administration is saying, but the major questions doctrine does not apply to Trump's tariffs. Okay? And so that's what Justice Sotomayor is getting at here when she brings up Biden.
Counsel, we have never applied it to foreign affairs, but this is a tariff. Is this a tax?
It is a, if I may, it's a foreign-facing regulation of foreign commerce. That's a regulatory tariff is distinct from a tax.
So Biden could have declared a national emergency and global warming and then gotten his student forgiveness to not be a major questions doctrine?
I don't think he could have gotten student loan forgiveness.
Why?
But
It's
perhaps
global. It's foreign-facing. We need all of these things to face to tax fossil fuel or to do something else. That's all Biden would have had to do with any of his programs.
Let me put it this way, if I may.
Is just declare some foreign-facing purpose?
If I may, maybe I can articulate it this way. The power to impose tariffs is a core application of the power to regulate foreign commerce, which is what the phrase regulate importation in IEPA naturally evokes.
Why
not the power to tax.
Could you tell me why it is that when Congress intended to permit a president to regulate by imposing tariffs, it's always used tariff and regulate? I have about 16 laws in the past that when Congress intended regulate to mean taxing, that it used taxes simultaneously. But it didn't here.
Respectfully, this court came to the opposite conclusion, if I may, in Algonquin, where the phrase was not impose duties.
But we did something in Algonquin. It was in the duties section, unlike here. It was paired with questions about decreasing tariffs and increasing tariffs. So it's a very different statute than the one at issue here.
But the governing language, admittedly, the references to duties in Section 232A, 232C does not refer to them, and the court didn't refer to 232A at all, or the phrases duties or tariffs as analysis. What it held was the phrase adjust imports, which includes a verb that's narrower.
But it was in the context.
It
was in context of activities that had to do with raising and lowering duties. Here, the verbs that accompany regulate have nothing to do with raising revenues in the form of taxes.
And, counsel, Algonquin wasn't a textualist opinion. Do you agree with that? In other words, the analysis that the court was using there was really keyed to the legislative history of that statute, and it wasn't as though we were doing an interpretation of the word adjust.
I disagree with that. I think you read the opinion. First, it talks about plain meaning, then it talks about statutory context, and then it goes on to legislative history. So it was all three of those. And the conclusion it came to, it directly addressed and rejected the argument that the D.C. Circuit had accepted in that case, which is that when Congress wants to delegate the authority to tariff, it uses a consistently explicit and well-defined approach, which is to use these magic words, tariff, tax, impost, and so forth.
Well,
Congress is not bound to use that particular formulation when it wants to confer this power.
Let me ask you about the premise of your argument, which you sort of started at the beginning saying that one would expect.
This is a really important point that Justice Jackson is about to make, and it will bring us into the third part of my framework: tariffs, taxes, and takeover. So she's about to ask a question that takes us into that part.
For Congress to give the president a broad leeway in this kind of foreign affairs context. And I guess I'm wondering whether you also don't have to contend with the actual purpose of IEPA in making this argument, because as I understand it, that the IEPA was designed and intended to limit presidential authority, that Congress was concerned about how presidents had been using the authority under the predecessor statute, TWIA, and it's pretty clear that Congress was trying to constrain the emergency powers of the president in IEPA. So it seems a little inconsistent to say that we have to interpret a statute that was designed to constrain presidential authority, consistent with an understanding that Congress wanted the president to have essentially unlimited authority.
I disagree with that, because what Congress actually did as...
What part do you disagree with? I'm sorry.
Well, I disagree with the notion that they were trying to constrain the breadth of the actions the president may take when it comes to this particularly narrow domain, which is, various regulations of transactions.
But how can you disagree with that? I mean, the history is what it is.
Because they made a series of changes to IEPA that relate to the triggering conditions, so to speak, and the procedures that apply, but they did not change the language.
Right, but what was the intent of Congress in changing the language? Wasn't it to constrain presidential authority in this area?
To constrain it in the triggering conditions and the procedures that apply in this
So those are the
context.
triggering conditions and procedures that apply are a means to constrain. That is how they went around about constraining. But my point is that Congress enacted this legislation with the intent of preventing the president from having unlimited powers in this area. And you're asking us to now interpret that statute consistent with an understanding that Congress wanted to allow the president to do pretty much whatever he wanted in this area.
Congress took the language from TWIA and enacted the very same language, and most important.
All right, so I'm going to let that do it because that brings out, we just heard them talk about, one, tariffs, taxes, and takeover, right? Tariffs, taxes, and takeover. And so the question is, are these tariffs really taxes that enable Trump to take over more executive power, more than what Article 2 gives him? That's what these tariffs, that's the question. And had we gone on, and we can't keep going, I mean, it's about 3 hours of argument there. Even the conservatives, Justice Roberts asked an extremely important question about whether or not this is a takeover. He doesn't use that word. That's my word. You know, just to keep it simple, tariffs, start them all with T's, tariffs, taxes, takeover. But that is a big issue because taxing is an Article 1 congressional duty or authority. That is not for the president. That's really important because the framers and the founders, remember, they were breaking away from a king. If a president under our system can tax, that's basically a king. That's why they divided up certain duties among the three branches to check and balance each other. If the president is able to tax, to run the DOJ, to run the military, to do everything, then that's why they've been having these no king marches. So these questions, if they were to decide that Trump exceeded his authority with these tariffs, that they're really just taxes that Congress should have done, that at least Congress should have approved pursuant to the major questions doctrine, then this will be SCOTUS's way of saying, we too don't want no king. So we just got to see how this turns out. It sounds like Justice Roberts, Justice Barrett, with questions they ask, are not with this, but they've been with him. If it's been 10 times, they've been with him like 8 or 9. So this guy, Sauer, he may be able to convince them to go along with this. If so, this will be big, folks. This will greatly expand Trump's power if he's able to essentially impose a tax in violation of Article 1. That would be really big. It would be another step toward authoritarianism in a really, really, really big way. That's what this case is about. The tariffs have raised, I think, a couple of $1 trillion. $2 trillion. And you heard those justices. I wish we had time for you to hear even Justice Roberts say that tariffs are taxes. He said it too. Tariffs are taxes. The Chief Justice of the United States of America said tariffs are taxes. And we know that Trump has said they're not. But they are. Because if a foreign country wants to import something here and there's a tariff, then the company here that wants that foreign product has to pay the tariff. And what are they going to do? They're going to get that money back by increasing the cost of the product that they're selling. So that is a way of passing that cost off to Americans, which is basically a tax. And so the court is grappling with whether or not Trump's tariffs are really just taxes that if they allow, they will basically enable him to take over even more, huge constitutional power. That's what this case is about. That's why this is so important. All right, so we'll stop it and leave it there. I am Reverend and Civil Rights Attorney Augustus Corbett. Thank you for listening to this video. And as always, you better stay woke.